Hi, I'm Emily, and I am here with Maya Murphy's attorney, Ephraim J. Fink. Attorney Fink practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fink is, what is the process of separation between an unmarried couple with children?
When a couple with children who never got married are separating through the legal process, two pieces of their separation will be handled in an identical fashion as if they had been married: custody and child support. The Connecticut family laws on custody and child support do not fluctuate and are not applied differently to married versus unmarried parents. First, let's briefly discuss custody. A custodial or parenting plan, whether by agreement or court order, will be guided by the best interests of the child standard. To be sure, in family law circles, this is still often considered somewhat of a vague and nebulous standard. Two reasonable parents can disagree on what is in the best interest of their child. The court will likely want some form of intervention before having to make a decision. That intervention would come in the form of either a family relations investigation with interviews of family members, as well as the collateral sources, depending on your children's age. And that means their teachers, coaches, therapists, and the like. Or the parties can opt for a private forensic inquiry with a guardian ad litem or GAL or a family therapist. To be sure, the modern goal for most child psychological studies is to usually find an arrangement to maximize a child's time with each parent as much as possible. This, however, does not mean that circumstances cannot be explored and positions taken if a parent's occupation does not allow for similar parenting time, or other circumstances dictate that one parent will wind up with more than 50% of the child's time due to other factors, including demonstrated fitness as a parent, expenses and financial needs of the child, and the child's emotional and social growth. Child support is also not affected as to whether the parties were married or not. In Connecticut, the court will look to the child support guidelines. These are regulations that derive information from the parties to come about a presumed amount of support. The parties' combined net weekly incomes are determined from the financial affidavits that are required to be submitted. And a chart showing the number of children are entitled to a percentage of the couple's combined income. From there, the income portions are prorated to determine who has the higher share of supporting the children, and that party is the presumed payor. Child support can deviate upward or downward from the guidelines. The parties can agree to this, and sometimes the court will order it if it is supported by a strong position argued by a party. Deviation can be based on total coordination of family support, one party having significant assets, special education needs of a child, extraordinary travel expenses, and also perhaps one parent having other dependents, meaning other children, and similar other factors. Two areas where being unmarried does make a difference are alimony and division of property. If you were never married and are legally separated, you cannot make a claim for and recover alimony, also known as spousal support. You also cannot apply the Connecticut divorce laws to divide and distribute assets or property because there are no marital assets. Nevertheless, this does not always mean you cannot get any contribution credit for assets you accumulated together. There are claims of unjust enrichment to be made to get back your equity, so to speak, if you and your former partner cannot agree on how to split up your acquisitions, especially if there is a lack of proof that they were intended as a gift to each other. For that, I direct you to further to my video on that very topic on our website. If you were never married, but you and your significant other had children together and now wish to legally separate, please contact me today at Maya Murphy PC at 203-221-3100.
Attorney Fink is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fink at efink@mayalaw.com, and please visit mayalaw.com for more information.